Contract law forms the backbone of business transactions and personal agreements worldwide. At its core lie two fundamental concepts: offer and acceptance. These principles determine when a legally binding agreement comes into existence. Let's explore the key rules and exceptions that govern offer and acceptance in contract law. An offer is an expression of willingness to enter into a contract on specific terms, with the intention to be bound if the other party accepts. This can be communicated through various means, including letters, emails, or even conduct. The key is that the terms are clearly communicated and there's an objective intention to create a binding agreement. For an offer to be valid, it must be specific, communicated to the intended recipient, and capable of acceptance. It's important to distinguish an offer from an invitation to treat, such as advertisements or auctions, which merely invite offers rather than constitute offers themselves. Offers can take several forms. There are express offers, clearly stated in words, and implied offers, derived from actions or conduct. General offers are open to the public at large, while specific offers are directed to particular individuals or groups. Understanding these distinctions is crucial for determining when a contract has been formed. Acceptance is the unequivocal assent to all the terms of an offer. It must be communicated to the offerer, either through words or conduct, with the intention of accepting the offer. The acceptance must mirror the terms of the offer without modifications, a principle known as the mirror image rule. Several rules govern acceptance. It must be communicated by the offeree, not a third party. The offerer can withdraw an offer any time before it's accepted. If a specific method of acceptance is required, it must be followed. Importantly, silence does not typically constitute acceptance, except in specific circumstances. There are exceptions to these general rules. In some cases, such as unilateral contracts, acceptance can be made through performance rather than explicit communication. In the digital age, click-wrap agreements and e-signatures have become widely recognized forms of acceptance. Speaking of the digital realm, modern contract law has adapted to encompass electronic transactions. Digital contracts, including those formed through websites or email, follow similar principles of offer and acceptance. E-signatures are now legally equivalent to handwritten signatures in many jurisdictions, facilitating faster and more efficient contract formation. In conclusion, offer and acceptance are the cornerstones of contract formation. An offer must be clear, communicated, and intended to create a binding agreement if accepted. Acceptance must be unequivocal, align with the offer's terms, and be properly communicated. While exceptions and digital innovations have added nuance to these principles, they remain fundamental to understanding when a legally binding contract has been created. By mastering these concepts, individuals and businesses can navigate the complex world of contracts with greater confidence and clarity.